Sir Edward Coke stated that murder is the unlawful killing of a human being under the Queen's peace with malice aforethought, express or implied. Express meaning to cause death, implied meaning to cause serious harm. The actus reus, which would be the unlawful killing in regards to the scenario, explain what happened in the scenario, and therefore actus reus is present. The mens res of murder is malice aforethought, express or implied. Express aforethought is the intention to kill, implied is the intention to cause serious harm. Maloney case study. In R versus Vickers, the House of Lords held that the intention to cause serious harm was enough for the mens res of murder. This was later repremished in the case of Cunningham. Referring to the scenario, the defendant's name, it was virtually certain that the actions of the defendant against the victim could result in serious injury. Actions explain what occurred. Willingham case study. Causation. But for of the defendant's act, the victim wouldn't have suffered serious harm or death. R versus White. As the causation in fact have been identified, the causation of law will also have to be applied. Legal causation. D. The defendant was the sole cause of the victim's death. Taking the victim how you found them. The victim was not suffering from any pre-existing conditions which would result in their death. Second element of legal causation has to be the operating and substantial cause of the death. Did the defendant's actions were the operating factors of the victim's death? Chain of causation won't be broken if the defendant's acts were a significant contribution. R versus Cheshire. Due to this, it shows that the defendant's actions were the substantial and operating factors in the victim's death. Due to this, it will show that the causation are being made out. To conclude, actus reus, if it was not for the actions of the defendant, the victim would not have died. The mens res for the murder is that the defendant must have the intention to cause serious harm or kill. As the intention of the suspect have not been identified, we'll have to identify them. The first question to ask is whether the death or GBH was virtually certain. Referring to the scenario, explain what occurred in the scenario and explain whether death or GBH was certain from the defendant's actions. The second question to ask are subjective. For instance, the defendant's name appreciate the case put towards him. The jury will be directed in the attention of the defendant. Was the defendant the sole cause of the victim's death? Explain this. As there's no intervening acts within the death. As the intentions have been established, which show a link between mens res and actus reus, this demonstrates these conduct of events during the unlawful killing. Now go on to explain diminished responsibility and loss of control. Diminished responsibility. Defendant's name could raise the defense of diminished responsibility. Diminished responsibility is a statutory offence and comes under Section 2, Subsection 1 of the Homicide Act 1957, amended by Section 52 of the Connors and Justice Act 2009. A person who kills or is a party to a killing of another is not to be convicted of murder if suffering from an abnormality of mental functioning, a state of mind so different from that of an ordinary human being would term it abnormal. Brian.J. This case involved a medical condition which was recognized in which a sexual psychopath inability to control his perverted desires pleaded diminished responsibility. A case of Ryans, Reyonds, a young mother killed her own mother with a hammer. Post-traumatic depression was the cause. In Martin, the defendant's paranoid personality disorder was accepted as a diminished responsibility. In Speak, mental deficiency was accepted as abnormality of the mind. Referring to the scenario, the defendant in question has substantial impairment of the nature of their conduct. In Lloyd, the court said that impairment need not to be a total but more trivial or minimal. Provide an explanation for the defendant's act and omission in having or being a party to the killing. Subsection 1, Connors and Justice Act 2009. State abnormality of the mental functioning. Provide an explanation for the defendant's conduct if it comes or is a significant contributor factor in causing the death of the victim. The second defense you can use is loss of control. However, as a partial defense, the defendant can raise the defense of loss of control. The law is set out in Section 54 of the Connors and Justice Act 2009. There are three requirements in order to plead loss of control. The first requirement of loss of control is that the defendant prove that the unlawful killing occurred due to a loss of control. In Ahluwalia, provocation was not available. This was because the victim waited for her husband to fall asleep before killing him. In Thornton, the defendant in question killed her husband after following a delay of abusive incident. The last straw was the cause of loss of control. Refer to the scenario, talk about what occurred in the scenario and how that intervened with loss of control. Referring to the scenario, the defendant's name had lost control when, explain what occurred. There must be a qualifying trigger. In the scenario, things said or done towards the defendant by the victim. This caused the victim to lose control. This constituted circumstance of an extremely grave character. Because of this, it is likely that the defendant's sense of being wrong was justified. In Richards, the provoked defendant may know what he was doing but was unable to restrain himself. The final requirement is the objective test. The objective test consists on whether a person of these, the defendant's sex and age, with a normal degree of tolerance will have reacted in the same manner as they did. Refer to the scenario, explain whether a person of that degree and that tolerance would react in the same manner. Finishing off the loss of control. In regards to the defendant's name, state the name. It is likely that a reasonable person placed in the circumstance of the defendant's name would have reacted in a similar manner. Therefore, this satisfies all elements raised to lose loss of control. If this was the case within the scenario, then the case of murder will be dropped to manslaughter. Non-fatals. Section 18, the actus reus are wounding or causing GBH. Mens reus is the intention to cause GBH. This is the most serious. Section 20, actus reus, wounding or inflicting GBH. Mens reus, intention or recklessness as some harm. Section 47, actus reus, common assault or battery. Mens reus, intention or subjective recklessness to common assault or battery. Assault, actus reus, causing apprehension of immediate and unlawful force or violence. Mens reus, intention subjective to recklessness. First, identify the crimes committed and write the crimes out, name in full. So if it's GBH, right, grievous bodily harm, the intentions, the mens reus, actus reus, and do it like that. Starting off will be the name of the defendant will be criminal liable for it'll be assault under section 39 of the Criminal Justice Act 1988, or a battery under section 39 Criminal Justice Act 1988, an assault occasion actual bodily harm under section 47 Against the Person Act 1861, malicious wounding or inflicting grievous bodily harm under section 20 Against the Person Act 1861, wounding or causing grievous bodily harm with the intent under section 18 Offences Act 1861. That's the most highest one. The actus reus of an assault can include an act but not an omission that causes the victim to apprehend immediate unlawful force. You can use Smith vs. Chief Superintendent, Working Police Station. Words alone, stalking, and silent phone calls can be the actus reus of an assault. Arvis Island case study. An example of assault, actus reus. By standing outside Jane's house and staring through the window at her, John has caused her to feel unlawful personal violence, and therefore the actus reus of assault is met. Battery is the application of unlawful personal force, and the slightest unlawful application of physical contact can amount to a battery. Wilson versus Pringle. So physical battery can include Arvis Dacre. Psychological can include like Burstow. The slightest amount of force includes hitting a person or causing them to drop a child. Hasted versus DDP. This is a case study where a person punched a mother and the mother dropped a child and the child was injured. The actus reus of a battery can be an omission. DDP versus Santana Bermudez. That's the case where the lady got harassed. Pushing Jasmine, Jim has inflicted unlawful force and the actus reus of battery is met. No battery equals no injury. ABH is assault occasional actual bodily harm, and therefore the defendant must have assaulted somebody and caused the injury of an actual bodily harm. An assault is a common assault, which means an assault is or a battery. Explained assault is non-touching and a battery is touching. Momentary loss of consequences can be ABH. Making verbal threats and chasing Jasmine so that he was so frightened that he fell over and was knocked unconscious. Julie has met the actus reus of assault, occasionally actual bodily harm, and Jasmine feared unlawful personal violence, which is an assault, and unconscious is actual bodily harm. ABH equals loss or breaking of teeth, temporary loss of sensory functions, loss of conscience, bruising, displaced broken nose, minor fractures, scratches, sprains, physical injuries that is more emotion. Wounding is inflicting grievous bodily harm, and only one of these need to be proven to meet the actus reus. Wounding requires that there is a break of the continuity of the whole skin, and therefore the internal bleeding is not sufficient for a wounding. JCC vs. Alzon-Hire, EISENHOWER. Jack has cut off John's ear, which is clearly a wounding, as the ear would bleed and both layers of the skin are broken. Grievous bodily harm, meaning serious harm. Case study DPP vs. Smith, or serious harm R vs. Sunder. Judges should leave it to the jury to decide whether an injury or severe injuries are grievous bodily harm. R vs. Brown and Stoughton. Really serious physical injuries can be GBH. R vs. Island. Jennifer has punched Jessica, who is 80 years old, several times on her body, causing her extensive bruising to her face and torso. Because of the age of the victim and the extent of the bruising, it is likely that Jennifer will be liable for grievous bodily harm rather than actual bodily harm, but it will be a matter for the jury to decide. GBH equals injuries resulting into permanent loss of sensory function, in which results in more than minor permanent visible disfigurement, broken nose, displaced limbs, or big broken bones. Then identify the mens reas. How does what happened in the scenario illustrates the required mens rea? Mens res of assault is the intention or recklessness as to causing the victim to fear the immediate unlawful force. By standing outside Jane's house and staring at her, John foresees the risk of causing Jane to fear that he may cause unlawful violence, but has taken the risk, and therefore the mens res of assault has been met. A battery is the intention or recklessness as to applying unlawful personal force. By taking the decision to push Jasmine, Jim has foreseen a risk of unlawful personal force, and therefore the mens res of battery is met. Section 47 offense is intention or recklessness as to causing the victim to fear immediate unlawful force or subjecting the victim to unlawful force. There is no need to prove the defendant intended or was reckless as to causing actual bodily harm. Intention is when the victim knows what he's doing. Recklessness is when the victim knows the consequences of what he does but does it anyway. Julie decided to threaten and chase Jasmine. In doing so, she was reckless as to whether Jasmine would be frightened of her. Therefore, the mens res of Section 47 has been met. Section 20 offense is intention or recklessness as to causing some harm, which is an ABH. There is no need to intend or be reckless as wounding or inflicting. GBH DPP vs. Parmenter. By punching Jessica several times around her head and body, it is clear that Jennifer intended to cause her some harm, and therefore the actus reus for Section 20 is met. Section 18 offense is specific intention to wound or cause GBH. Intention to avoid arrest plus intention or recklessness as to wounding or causing GBH. Factors that indicate specific intent may include a repeated or planned attack, deliberate selection of a weapon, or adaptation of an article to cause serious injury, such as breaking a glass before an attack, making prior threats, using an offensive weapon against, or kicking the victim's head. When you're finishing it off, you state it, in conclusion, Jim, or the defendant name, met the actus reus and the mens reus for whatever crime, like GBH, ABH, and therefore would be liable for, explain the punishments of ABH, GBH.